attorney Byron Browne. And Byron, first of all, let me ask, were you at all surprised that the state chose to exercise a preemptory strike with that particular juror, knowing that they only have a total of 3 strikes for the jury of 12?
Yeah, I was surprised. I thought they would try to move for cause. What the prosecutor was doing there is he was trying to show the court, in my opinion, he was going to move for cause after showing the court that this witness was so biased, potentially in favor of police, that that juror could not sit just based on bias and prejudice. Because in the state of Minnesota, just like you just indicated, they do have preemptory challenges. Each side has 3 that they can use for any reason, as long as that reason does not involve, a protected area such as race, gender, or ethnicity. And so I thought what he was doing was setting up for a challenge for cause, which would not have counted against one of his preemptory challenges. But obviously, him and his team, after they had a little caucus off to the side, they decided to use one of their preemptory challenges. And it did seem like that juror would probably be more biased in favor of the defendant than the prosecution. So I agree with what the prosecution did in that particular circumstance.
And did you feel like, I just have to ask, that she was at all perturbed by the prosecutor's questions? And I felt like when he was asking about, do you understand that if there's an expert about firearms, for instance, it's not about your expertise and your training as a security person at a church, but rather about the people in trial. I don't know. I felt like maybe she was getting a little frustrated with the questions, but what did you think?
I felt the same. I thought she was getting frustrated. And to be honest, most jurors in that particular circumstances in voir dire, they're getting asked personal questions. And obviously this case touches a nerve more than most with all the other circumstances around it. So I think like most jurors, it's kind of like, hey, listen, I want my privacy to be my privacy. At the same time, you have a constitutional requirement here to be a juror potentially. Again, something common we see within this phase, but I agree with you. She was leaning on the side of being unimpressed with his questions.
And Byron, while we have a couple more minutes, let's talk about the overall general process, because I like to watch all the different social medias because viewers have great questions. And one of the viewers said, hey, can you choose not to serve if you are selected to serve on a jury? And we know the answer is no. If you're selected to serve on a jury, you're expected to serve on the jury. But I want to look at the specific process for Minnesota. There were really 3 phases as broken down by Court TV, not by Minnesota, but I think it illustrates very well. First of all, that the jury is a panel of 7 potential jurors. Phase 1 is when the judge, you've heard Judge Chu read general instructions and make the introductory remarks, very consistent, very same demeanor for all of these potential jurors. She then reviews or reads the charges, and then she asks general questions for the panel for any show of hands, although she hasn't done a lot of that. Phase 2 gets into the individual questions, and so the judge asks questions based on the jury questionnaire, and then the defense actually goes next to ask clarification questions, and then the state has that same opportunity to get those clarification questions. Now, there are 4 different results. As a result of phase 1, phase 2, what happens to each potential juror? Necessarily one of these 4 things is going to happen. Either they're going to be struck for cause by the court or released by the court for a medical condition, for instance. Next, they may have the state preemptive strike or the defense preemptive strike. And if none of those 3 things happen, then they're selected to the jury. So, Byron, I'd love to pick your brain about jury questionnaires and whether or not you think in a case of this magnitude, this happened during the Chauvin trial, accused of and then convicted for the death of George Floyd. This all happened. Do you think that jury questionnaires are an effective tool and should have been used in this case?
I do believe a jury questionnaire is a useful tool, and I do believe that this is an appropriate case for a jury questionnaire to be utilized. We use jury questionnaires in situations like this when we know that we might kind of run through a lot of potential jurors. This is a hot topic button sort of issue socially for people. People are going to have opinions about it. So I think what a jury questionnaire does is it kind of shortens up the potential process of maybe people answer questions within that questionnaire that clearly shows that they're biased and prejudiced to a point that they can't sit on a jury. Well, and then they can be struck for cause right off of the bat. And then we can limit the pool down to a section of pool that we think that might be more likely to be unbiased and unprejudiced to sit on that jury. So it saves time. And at any trial, the judge probably one of the biggest jobs a judge has is to ensure that that trial moves smoothly. And I think that's what the judge is doing exactly in this particular case.
All right, Byron Browne from Arizona, thank you so much for your time today and offering all of your expertise. We certainly appreciate it and your analysis. Coming up next, historic argument.